show a reasonable necessity for the taking. And that's the Siemens v. Davis case, 196 Arizona 411. The elements that we've shown that show that in the event there is not an implied way of necessity, that in a private statutory way of necessity is present. First is that the plaintiff owns 998B, and that's from the statute and from Dabrowski v. Bartlett. The Exhibit 17 shows that the plaintiff is entitled to the parcel. That's not contested. The way is sought for one of the statutorily enumerated purposes in the Act. This includes domestic, which the courts define as residential purposes. The testimony of Mr. Sigston, among other testimonies, evidence is that this was indeed a residential lot intended for residential purposes. The third one, there is no access by implied way of necessity. Of course, we believe that there is. If the court were to differ, this count is pled in the alternative. The fourth element, there's a reasonable necessity for the taking, including when a property is landlocked. But the Dabrowski and Solana cases I cited make clear that landlocked is not even the standard, but the lesser requirement that the condemner needs not, they don't have to show an absolute necessity for taking. They just have to show a reasonable necessity, and that's sufficient. The evidence here shows that 998D did indeed have no legal access. They didn't just have unreasonable access, but none. So there are cases of condemnation where there actually is other access, but the court finds that it's not reasonable, sufficient to say that they can grant a different statutory way. In this case, the Glenmore 2 and Troon plats, as well as the aerials and the testimony regarding those, show that there is no, there's a reasonable necessity for access to the public roadway. The fifth item, there's no adequate and reasonable alternative legal route. The important distinction here is that, again, it's an adequate and reasonable alternative legal route. The Dabrowski case makes this clear. It says, when determining whether a reasonable necessity exists, the court looks to whether the proponent of the private condemnation has an alternative legal route that is both adequate and reasonable. So there's three pieces there. It's a legal route, it's adequate, and it's reasonable. But directly on point to this case, it's something that we want to be very clear about. I'm going to read directly from Bartlett. And it starts here. It's a heading that says, Bartlett is not required to seek alternative routes. The Dabrowskis argue that Bartlett is not entitled to a private condemnation because Bartlett failed to establish both that the town of Cave Creek would not allow Bartlett to build a roadway to the west or south of Bartlett's lot, and that he could not obtain an easement to the west or south of the lot. Thus, the Dabrowskis contend Bartlett failed to show a reasonable necessity for the taking. The Dabrowskis do not offer legal authority for this contention. Bartlett was not obligated to explore alternative outlets for which he did not have legal access. And then it quotes from the Solana case, there is no merit to defendant's contention that the statute permitting residents to petition to establish a highway gives to plaintiff an appropriate and expedient method of obtaining a means of ingress and egress to his property by petitioning the Board of Supervisors for the establishment of a county highway, providing for condemnation at the instance of a private party. The framers of our Constitution, as well as the legislator, affirmatively rejected such a contention. And then it continues after that quote. The court found that Bartlett's potential legal access was inadequate and thus correctly granted him a private condemnation through Lot 1. So the Bartlett case clearly says that alternative routes must be routes over which the Bartletts had legal access in order for them to be available. So guess what that means in our case? The evidence that we've presented makes clear that the plaintiff doesn't have this legal right. They can't access the two routes that the defendants have proposed that we looked at on the south side by the wash and on the west side in the cul-de-sac going into a different, the Glenmore 2 plat on one side and the Troon 3 plat on the other. That fact was not disputed at all. It's in the language of the plats. It's in Glenmore 2, that's Exhibit 38, I believe, and Troon 3 at Exhibit 36. There's another point that makes this obvious, though, not necessarily given the above. Going through the plat road turns the entire road into an open public way that anyone can use. And that means basically the gates come out. It's a burden not just to get to the road as was presented some at trial by defendants, but it's a burden on each of those 32 houses in Glenmore and the 100 odd, I think 107 in the subsequent Glenmore 1 plat. Those lots are in the plat. And then on the other side in Shroom 3, there's 30 lots that are affected. It's not, hey, we're going to let plaintiff drive through here. When the private condemnation happens, it opens that road up to everybody. So the burden, that's a significant burden there, especially considering the gated nature of those parcels or those plats. I quote here then from the Siemens case: to appreciate the trial court's finding of detriment to defendants, one must understand that what is called a private way of necessity is not private at all. When a way of necessity is condemned, its use is not limited to the condemner. Instead, the condemned roadway becomes an open public way which may be traveled by any person who desires to use it. And that was again Siemens v. Davis, 196, Arizona 411. So again, what's the reality of this? This would mean the gates at the front have to come out because it's been condemned now to provide free access through there, not just for plaintiff, but for all traffic through there. So the impact is, if this was the narrow context we're looking at, that impact would be much more pronounced than the impact on two undeveloped vacant pieces of property. But I do want to stress again, this doesn't actually even matter in this case because the reasonable alternative test is the reasonable legal alternative. In other words, there needs to be a legal right to even go that way. So what we could look at is, are there other reasonable routes through the properties, through the 998 properties? And as opposed to routes that we looked at where we have no actual legal success. A couple of other items on this statutory private condemnation. The first here is that the condemner chooses the condemned route across the defendant's parcels. This comes from the Solana case, and that case states the condemner makes the initial selection, and in the absence of bad faith, oppression, or abuse of power, its selection of route will be upheld by the courts. That case site was 69 Arizona 117. The Dabrowski case also says that the defendants were free to present evidence of the costs and other details of a route to show that there is a more reasonable route, but this route had to be across their parcels. They're not other parcels that we're crossing. It cannot go on to parcels that 998D doesn't have a legal right to go to. So the only clear evidence in this case that the court has comes from the testimony of the two surveyors who testified that the route proposed in Exhibit 31 was the least obtrusive route through the parcels. Therefore, the route that's been proposed here across 998 is uncontested. Then to the last element, for condemnation, there's just compensation paid to the condemnee. The trouble is in this case is, well, in every case actually, it's defendant's burden to prove the diminution in value caused by the driveway. This comes from our Supreme Court's case, State ex rel Ordway v. Buchanan, 154 Arizona 159. And that case says severance damages are proper when the land condemned is part of a larger parcel. The measure of severance damages is the difference between the market value of the remainder before and after the taking. As with the valuation of the part taken, the market value of the remainder is determined by ascertaining what the property would bring on the open market, assuming there is a willing buyer and a willing seller. The condemnee has the burden of proving severance damages. We've touched on this a little bit in trial. While an owner may testify to his property's value, any explanation he gives must consider the weight of the evidence given the valuation. The court must consider the weight of the evidence given to that valuation. Where does this opinion come from of the homeowner? And that opinion, as I've stated, is limited. From the Board of Regents versus University and State Colleges of Arizona v. Cannon. This is 86 Arizona 176. That court states, in condemnation proceedings, a witness's opinion as to property value not supported by facts, but based upon sheer speculation, is not competent. In our case, Mr. Solberg plainly, in his own words, admitted he had no actual factual basis supporting his $400,000 claim, the number he came up with. Those were his words. That claim is, I think, even more dubious when you consider that he claimed his property was worth 1.2 million, and then I think he adjusted that up. He said that was conservative. A year and a half after he purchased it for $250,000, he lists it for $1 million. Now, keep in mind that million is less than what he testified today the property is worth. We went through the reduction in prices that he made over the course of those 2 years he was trying to sell the property, all the way down to $779,000, and it still didn't sell there. So it hasn't sold at all at 779 or below. The Gong's valuation was, well, Mr. Gong's valuation was, oh, Mr. Solberg said it was worth 400,000. All right, I guess I'm going to claim it's 400,000 on my half. And Miss Gong's numbers have the same issue. They were based on the value of a completed house and never actually gave a clear diminution value or how she came up with diminution or severance value. So the problem there is we're not valuing a possible house. We could put a $40 million house on there. That's not the condemnation value that the law requires. The other issue is that wasn't her testimony. She said she testified she gets all of this information from her realtor shortly before trial. That's the testimony of the realtor, not Miss Gong. Of course, the realtor was not a witness, was not listed as a witness. The court saw none of these reported comparables, not where the values were, not what they were sold for, not what those houses were characterized, not even when the comparable sales were made or the realtor's name. So to attempt to funnel this work product of the realtor in after not naming them or disclosing any of the underlying documents is exactly the type of evidence that is not, or testimony and evidence that is not permitted. There's no foundation for it. There's no supporting evidence. The case City of Tucson v. Rickles, 109, Arizona 82 states, remote and speculative damages should be disregarded games of let's pretend. Should play no part in condemnation cases. The court then further said on speculation, valuation that's resting on speculation and assumptions, which were not justified by evidence, is improper as a matter of law. Finally, because the defendants failed to meet their burden to show damages, they're entitled to none. This is shown in the Pima County v. Palos Companies Unlimited, 140, Arizona 481, where when no evidence was given for damages resulting after condemnation, the damages award was vacated by the court on appeal. We believe the court should find an easement by implied way of necessity. If it does not, the evidence shows that plaintiff is entitled to a statutory easement with payment of only a nominal sum because defendants failed to carry any burden of showing a reasonable measure of damages based on actual evidence. And because the easement granted is a non-exclusive easement, that wasn't considered. The square footages, we don't know what's even impacted by this. So the short of it is there's no valuation that the court can pin to it, and the defendants haven't met their burden there. As I mentioned earlier, we also request the attorney's fees under the Arizona 12-1103B. Thank you.
Thank you, counsel. All right, Ms. Wilson, Mr. Martineau, who would like to go first?
I think he's going to go first.
All right, whenever you're ready, counsel.
All right. Your Honor, plaintiff Redevco has two claims, of course, implied way of necessity, implied and the private condemnation. First, with the implied way of necessity, plaintiff has the burden to show that his parcel had no other access at the time of severance in 1985. This is their burden. Defendants don't have this burden, but they showed anyway that this parcel did have access. The aerial photographs are clear. At the time of severance, vehicles accessed plaintiff's lot through dirt roads that led northeast from this lot. This is virtually indisputable. In his motion for summary judgment, plaintiff called these dirt roads construction paths, which suggests that heavy machinery might have used them, and heavy machinery could have been used to build on plaintiff's property. Maybe so. At trial, in an opening statement, he referred to horse trails, I believe. But these trails weren't made by horses. We can see the size in the images. The fact is those dirt roads were used to access plaintiff's property. The only question then is about the legal significance of these dirt roads. Was it trespass to use them? Plaintiff suggested this earlier, but he has no proof either way. Plaintiff says that there was no recorded access granted and suggests that Arizona law requires recorded access. You made that in the opening. I don't think you made that statement in the closing, but that statement is untrue. There's no Arizona case that requires the access at the time of severance to be recorded. And there is an Arizona case with the opposite holding. Now, there's been a discussion about, is this, can this case be differentiated? But the plain language of this case says the opposite. A lack of recording does not show a lack of access. And this would be the College Book Centers. They've cited it a few times. 225 Ares 533. And I'm going to read a little bit from that. Vanyo asserts that because there has never been any recorded access to Miami Mod, the only logical conclusion is that there has never been any legal access. Then the court said, we do not agree with Vanyo that the 1912 land patent silence regarding access is sufficient to establish a lack of outlet at the time. Even if there's nothing recorded, there can still be an outlet there, and the lack of outlet has not been proven. Plaintiff makes a new argument in closing that, and he says that Arizona case law requires more than just a license to use, more than just a license over property to access the property. Again, this is not true. There's no Arizona case law that says a license or a temporary permission to access the property is insufficient. He cited a lot of cases, none of them say that. The specific case that they cited was an unpublished one, Sundance v. Cutler. Again, this case says the opposite, and I'm going to, there it is, New Sundance Limited Partnership v. Cutler. Honestly, it's an unpublished case. The reasoning is pretty convoluted. I don't think it's really correct. I think it got some things mixed up, but there was never any statement that a license is insufficient for access. And that analysis would be in paragraphs 5 and 6, kind of the pertinent facts, and also paragraph 28. Also, the person in that case who wanted the implied way of necessity and who had to show a lack of access at the time of severance, the court ruled against them. Okay, the court, in other words, they didn't get their implied way because they actually did have access at the time of severance. They were using a ranch road, and there's no evidence of, was there a license? Was there an easement? They used the ranch road, and presumably because of this use, an implied way of necessity was not imposed. But like I said, the reasoning in that case is pretty convoluted. I don't think it's going to be very useful. Big picture, a temporary license at the time of severance is sufficient access. And this makes sense. The reason why someone would ask for an implied way of necessity is because they don't have permanent access. If they had permanent access, they wouldn't need to bring a claim. Sometimes they had temporary access at the time of severance, in which case the claim fails because at the time of severance, no easement was needed. And that's what was the case here. Plaintiff has the admittedly difficult burden of proving this lack of access. It's almost like proving a negative for something that happened 40 years ago in 1985. But it is his burden, and that doesn't change with passage of time. He had no evidence on this point, and he did nothing to rebut the photographs of the dirt roads that were actually used to access his property in 1985. He also mentioned an attorney fee award. Attorney fee award is not necessary because his claim for private way of necessity fails. It's also inappropriate given the hard evidence that shows plaintiff's lot was accessed by alternative way at the time of severance. Big picture, both claims require reasonable necessity for the proposed easement. And the case law cited by the plaintiff will have this language, reasonable necessity. But the proposed easement is not reasonable. If it's constructed, the roadway would destroy a pristine desert landscape. It would shrink the footprint of any buildable area on the Gongs and the Solbers property, and it would introduce traffic into their backyard. With the health and safety concerns that come along with that. If this road is being used for construction, and if the public can go on it, that would see even a worse impact. Even if this easement is granted and nothing is built, an NAOS dedication would have to take this easement into account, and the easement alone would diminish the property value severely. And plaintiff's witnesses agreed, taking up NAOS lowers the buildable footprint and can significantly diminish property values. I want to go back to the necessity. For access to be necessary, it has to be possible. But here, nobody has evaluated the proposed roadway to see if Scottsdale is likely to approve construction. Remember, this is within environmentally sensitive lands overlay. Nobody performed an analysis regarding slope, NAOS, environmental features, plant revegetation, geotechnical report, or drainage report. Mr. Sigson did not know whether a roadway could be built around large boulders that were partially inside the proposed easement area. He specifically looked at those when I pulled that up, and he had a close look at that on his on Mr. Sadbury's aerial photos of that. Plaintiff has not shown that they are legally able to build a driveway or develop their own parcel, even with an easement, even if they had one. There's no evidence that a roadway would or even could be approved through this delicate desert landscape. If an easement can't be used, then it's not reasonably necessary. Plaintiff also didn't prove why other shorter routes were not feasible. And again, we all saw the maps. We also could see that these other routes have as far as square footage is concerned, a smaller footprint, smaller impact on desert land. Plaintiff chose where to put this easement. His experts didn't. Plaintiff told Mr. Sadbury where he wanted this easement to start and end, and Mr. Sadbury drafted that first easement. This was plaintiff's choice. Mr. Sadbury did not choose that route. He didn't look at any alternative routes. Mr. Sigson admitted that when he was looking at different alternative routes, one of the primary reasons that they didn't go through the closer cul-de-sacs was because they didn't want to go through a community. That's not a valid reason to create a larger impact on defendant's property. There wasn't clear testimony on this, but it seems that they might have chosen the route to minimize plaintiff's cost. They were talking about walls and such. But again, this isn't a valid basis for choosing the easement area. They did no analysis, and both of the experts admitted this. They didn't do any analysis on the impact of the proposed Servian estates. They didn't do any, and then they didn't do this for the proposed easement or for the alternative routes. They didn't look, and they did not look at the routes that would have been, and they did not do an analysis of the other routes that would be more reasonable with a smaller footprint. So, no, the argument is not that because there were alternative routes, the claim automatically fails point blank. It's that these other routes show a lack of reasonableness. Because there are other reasonable alternatives, then this much longer route that with a much larger impact, it's not reasonable, and that's something the court should take into consideration and should deny the easement on that basis. And like I said earlier, reasonable necessity, that's the language for both claims. And So that's why both claims should be denied on that point, and they can be denied on that point alone. We'd like the court to keep in mind that plaintiff is, of course, a sophisticated entity, and also this case should be barred by laches and estoppel. Plaintiff and the predecessor in interest sat on their alleged rights, and the Gongs bought the property, and they held it relying on the absence of a roadway easement and all that implies. They relied on pristine desert landscape, NAOS that allowed a suitable build, a peaceful backyard, a place to build their dream home. If an easement is granted, the Gongs will suffer substantial prejudice. To summarize, plaintiff failed to prove implied way of necessity. He has no evidence to support the final element, and the 1985 aerial images show that he cannot support this final element. That leaves the condemnation, private condemnation action, which shouldn't be granted, but if the court grants a private condemnation, then it should have assigned a value to the proposed easement at the value testified to by the defendants, $400,000. Plaintiff presented no evidence on the diminution of value. His burden. So the defendant's testimony should be accepted fully. Mr. Gong and Mrs. Gong, they talked about, they found that houses in that area were going for $800 per square foot. We can do simple math. They said that the NAOS impact could impact their buildable square footage by 500 to 1,200 square feet. That's between, I mean, if you just multiply that out, that's between 400,000 and about $1 million. And there are, of course, other reasons that this would diminish the value, which would be a road through your property and you don't have the nice view and, the lack of peace and quiet, et cetera, et cetera. This was not mere speculation. They went ahead, they did comps, they measured, they're familiar with NAOS, they know what the building requirements are, and they've done calculations, even if it's not precise calculations, even if they didn't hire an expert, this was not simply speculation. They had a basis for saying that at a minimum, $400,000 would be the impact, the diminished value on their property. And just to reiterate, plaintiff, he just said, he said no valuation. He said there's no valuation that the court can pin to it. So he's admitting he didn't provide any evaluation. His burden to do so, he can't attack the Gong's testimony if he didn't provide anything to the contrary. Plaintiff is asking the court for a windfall. He's asking for a free easement to serve plaintiff's property. A free easement that would impose enormous costs on these lower parcels. The court should not give plaintiff a windfall at defendant's expense. And that's all I have.
Thank you, counsel. Ms. Wilson.
Thank you, Your Honor. I'm going to try to be brief and not reiterate everything that counsel just said. And we've been sitting here for a day and a half. I think you've taken a lot of very copious notes and listened to all the testimony and have all the evidence. Go back to what I started with, and we need to look at really what's going on here. We know the elements, we know what's required. This is a property that plaintiff purchased 9 years ago. It's a property that, when we go back to the key date of 1985, so 41 years ago, what's happened in that time? The plaintiff's predecessor is the one who created any, I guess, technical legal landlock. And that the plaintiff's predecessor, they've presented lots of deeds and lots of plats, and there are a lot of things going on there. But what's clear when you look at the evidence, and again, and I'll reiterate the point that my co-counsel here made, this is plaintiff's burden. This is their burden to establish, and they need to establish that they lacked an outlet in 1985 at the time of severance. That is their burden. And when you look, there's no question, there's been no evidence that anybody, not even speculation, has ever, since that 1985 date, ever crossed across our client's properties from his client, from plaintiff's property. That's never gone that way. The only evidence we do have is what we've seen in the 1985. They have to prove the lack of access. And I'm not going to reiterate because I was going to say a lot of what Austin already said. But again, I refer you back, and I mentioned it in our opening, prior to your involvement, the court heard, or the prior judge heard oral argument on this, and we addressed these issues. And what the court said then was these photographs are ambiguous and don't answer the question. Well, nothing has changed. And it's not our burden. It's his burden to prove lack of an outlet. I will again refer, I think, the college bookstore case. There was a lot of talk about that. They were talking about Vanyo did not present any historical evidence at trial other than these surveys, and he had the burden of proving the lack of an outlet. He couldn't do it. It's all he brought in that case, and that court said that's not proving a lack of an outlet. And there was this discussion about, Vanyo argued basically that any grant of rural property without express access that occurred prior to advent of the automobile and expansion of the roadway system could never give rise to implied easement. And the court disagreed. That's not what we're looking at. It is, what was the lack of outlet? First of all, that's their burden to prove, but it doesn't have to be a paved road. It's what, and I think that's why I think it's also very important, and I may sound like I'm beating the dead horse, there's no indication anybody ever got up to Happy Valley Road from plaintiff's property for 41 years by going through our property. The only indication of any outlet, we've actually presented it, and it's the other way out. And that's very important. And I'll get back to it, but the college bookstore case is good because Vanyo was very much arguing, look, if I can't get out, I don't have any access, I'm going to, it's going to be landlocked forever. And that's when the court turned, which we'll get to in a minute, and said, you've got another remedy. That's the private condemnation, which is where I started this case with. This is not an implied easement by necessity because they can't prove the lack of outlet in 85. It's a condemnation case. In any event, still kind of following and finishing up on the implied easement, there's been a lot of discussions about, and today now in closing talked about, what a burden it would be for these alternative routes to go through these other subdivisions. Well, okay, maybe. I mean, that's speculation. We don't know exactly. He says now it's open up to the whole public. I mean, again, that's his speculation. Not only are the Gongs and Solbergs directly impacted, what about those 8 homes now that he's going to put a road right behind? How close is that coming to their back wall? Do we know? I mean, how are they going to like that? They all sit, and you saw the aerials. We've seen you saw their exhibits. I'm going to say 30, but it was Mr. Sadberry's, and where he has those lines, how close they are to those walls. And that's 8 homes this road is going to go by. And they are now going to be, and I think Mrs. Gong did a really good job of pointing out some of the things that I think maybe not everybody else is thinking. This isn't just a nuisance when this road might be built, however long it would take. And then, in fact, if he did build a house there, how many years is that going to take? But it's that everyday traffic. And both Mrs. Gong and Kevin, they both talked about the fairway views. These people in these 8 houses, how are they going to like now sitting in their backyard and there's a road 5 feet from or 10 feet from their backyard in the middle of their view, a pristine view? So it is an impact. And you know, the problem is there is a significant impact to everybody on this, but it is a huge impact because they sued us. We're the ones here talking about it and what it is. And I think it's important as I sit in, you know, I'm not going to say I come to court and do a lot of trials, but certainly we do look at credibility of witnesses. And as I've been sitting here these 2 days, I think, that our clients have explained why they believe there's other alternative access and how an impact. But one person stood out to me, as I would take it as we had one truly neutral witness. And I think that's Alan Sadberry. I don't think Mr. Sigston, who testified for well over an hour and continued to refer to the 998D lot as our lot. I'm not sure why he kept calling it our lot. But Mr. Sadberry, the first surveyor, I think he truly is a great person to look at his testimony. And I do want to make sure it's clear on the record, because counsel misrepresented Mr. Sadberry's testimony when he was talking in his closing. Mr. Sadberry didn't look at the other routes because he was told which way to go. He was told start and end, and he was very clear. He was told where to start and where to end. And on his own, he came up with, and I found it very coincidental, that he came up when he was asked, is there any other routes? He came up with that one along to the east by that one house that has a pool. He came up with that on his own, which just so happens to be what our clients had been thinking about as well. And his comment was, yeah, that seems like a good alternative. But he wasn't told by plaintiff, go tell me what's the best way out or what's the easiest. He was told by plaintiff, start here, end here. And I think that's very telling. And just to kind of follow up on the topic of that, of Mr. Sigston, their surveyor, again, our lot. So I'm not sure what his position is, but I don't know if you might recall, counsel really attacked Kevin today about the fact that, about where that line was, about that house and your blue lines on their driveway and it's in the wash. Have you walked the wash? You haven't even walked the wash. You don't know how much. Mr. Sigston, their surveyor, who's now opining, and it appears they're relying on that he says all this can be done, has never even been to the properties. Never. They did their work in 2020. He didn't sign that letter. He had survey crews he sent out. He didn't even go out there. So, and he admitted during his testimony, yeah, the easement might go over some boulders. I'm not sure. And I think we all understand that there is a process and you have to go to the city and get approval. But we don't know that that's going to go into my next point is, and I think Austin said this very well, I don't think that this is even a feasible road. And I think that's something that is very important that I want to make sure this court understands. And that's why we're trying to show, and we did the topography and showing this, there's a lot involved. This is a 1/4 mile road. And in a hillside conservation, whatever the proper term is, the ESL, you've got all these NAOS, and there's a lot of setbacks. Mr. Sigston is not a contractor, and he can opine what he thinks it might be, and it could, it's easy, or opine about the scour wall. Again, mind you, he's never been to any of these properties, but he's not the one. He did not look at the city requirements. There's going to be HOA requirements, and that is important too. He talked about not wanting to go through an HOA. Our clients' properties are part of an HOA. They're part of Troon Village Association. So you have all, in which my client thought plaintiffs was too. But the point is, there are a lot of restrictions. There are, Mr. Gong testified, 50 to 100 cactus. Removing and replacing a cactus is a tremendous expense. And while maybe cost doesn't come into if they want to put it how much ever money in, but there are a lot more things that we need to be looking at. And can he really move those boulders if there's boulder protection? Can he do what he really is proposing from this easement? He didn't bring in anybody from the city. He didn't bring in a contractor. He didn't bring in anybody from any HOA, anybody that can testify to say, yes, we don't even know sitting here today if 20-foot width would even be approved, let alone setting aside everything else we've talked about. So this is not 100-foot straight driveway that doesn't have, it may seem like such a simple thing when you think about it out loud, you're like, oh, it's just putting in a road. It's not that simple. And up in that community, this is a huge issue. So he could be awarded an easement that's a paper that will destroy our client's property for as long as they own it. That could never even be, it would be a futile exercise because it could not be done. And they can say we didn't refute any of this. Again, it's not our burden. This is their burden. They're the ones who chose. Mr. Wickman and specifically chose this place of, I want to start here and end here. And he has the burden. So I don't think that it's at all feasible. And setting aside the fact that he had an outlet in 85 from a different way. Again, I think the college bookstore then ties it in very nicely with saying, acting like, well, if you can't get to it, I have to have this implied easement. And that's when the court said, you got to consider the Arizona Constitution provides a remedy, which is this: if you can't establish a right of access by implication, prescription, or otherwise, you may nonetheless be able to obtain access. And that goes then to the private condemnation. And that is when you do, as we've talked about, and I mentioned at the beginning, that is when you do look at things like feasibility. You do look at cost. And again, if there's more reasonable routes exist. We've all looked at them, and that's very important that we all understand what can be done. This is just really not a reasonable route, and there are other options. To the extent you consider that, our clients have testified. You made it very clear. We've been through this many times. A homeowner can talk about the diminution. They can talk about from what they know, from what they've looked at, what they understand. Kevin talked about the 25% diminution. We look at the values. This, again, is huge because of the way homes have to be constructed with a certain amount of NAOS percentage. It's like whatever, 30%. And you have to have setbacks. You have to do all these other things. That is a huge impact. And they've given their best educated guess from what they know and looking at everything of $400,000 to each of them. And they have not refuted it. They didn't, nobody stopped them from hiring an appraiser. They didn't. They didn't bring in a realtor. They didn't bring in comps. They didn't do anything to refute our client's damages. And I will go back to Mrs. Gong. I also think she, as I mentioned, talked about this isn't just, it is a big monetary, and it impacts this in such a huge way that there is a cost involved with that. Plaintiff bought this property 9 years ago. It was landlocked. He knew it. He is delinquent in his taxes on it, about 18 grand. And yet he now wants an easement across our client's property for free, not wanting to compensate them and not even acknowledging or even taking the actions necessary to see if what he wants to do and destroy their properties would even, if he even could be allowed to do it. Certainly, I do not believe, I think back just to that college bookstore case, he has not proven lack of access, an outlet in 85, so he doesn't get the easement by implied way of necessity. And when you go to private condemnation, I don't think it's through our properties. I think we've seen enough of alternatives. And then if for any reason it's considered on ours, which again, I don't think ours are the routes to go, at a minimum, $400,000 to each of ours. And we would also ask for our attorney's fees in defending the implied easement of necessity. Thank you.
Thank you, Ms. Wilson. Jander, rebuttal.
Right. Be brief here because I think most of these things we've touched on, and I know that the court is going to make a careful review of the case law that I've cited. I did want to point a couple of things out. One, from a factual standpoint, there was no evidence of any vehicles anywhere other than on the section 10 portion of Happy Valley Road while it was under construction. That's an easy verification for the court. There was confusion here about what the standard was. I didn't say there was a requirement that there be a recorded easement. That is the typical way that a legal right for property to have access over another parcel presents itself. But that's why I specifically said the requirement in the case law is legal access. What is legal access? Well, it is recording, or if you go and look at that College Book Center's case, and it is worth a careful read. I think it's very important, but that's also virtually the only case cited. The actual evidence there was a survey showing roads, showing to Cave Creek Road on a survey. It wasn't showing a picture with a dirt path that we've spent the last 2 days speculating what that is. That's a very different case. The other thing is, in this case, we've done more there. They said, oh, well, we don't see access rights here. You've seen specific, the court has seen specific language in both plats on either side saying, hey, these roads are expressly not for anybody but these houses. That's very different from what the college bookstore case was stating. I think I would point the court to paragraph 32 in that opinion. There's also a footnote 10 that describes what's actually happening here. It's the survey there shows roads to 4 different mining claims, which those mining claims themselves had access to a public road. And in that case, the plaintiff did not show the lack of, it did not show how that evidence is rebutted. That, hey, there's this legal access. What do you do about this? That case wasn't about, hey, here's an aerial from right before all of this stuff was under construction and a path appears. It's a very different case. And when you read those other cases when the court reads those other cases that I cited about the standard being legal access, that becomes very clear. The context makes it very clear. The Sundance case, I know that the court will read it, and what the court will find is it could take a couple reads. Sometimes these opinions, especially when they're in a vacuum for us, not being in trial in that case, are a little more difficult to read. But in this case, the court will see there's the ranch road, and they're right. There was an issue, but this issue was the plaintiff being denied a statutory way of necessity because the court found he could have had an implied way of necessity. That party believed he did not have an implied way of necessity because he thought he had access to the ranch road. So he said, I got access to the ranch road. I'm not chasing an implied way of necessity. I'm going to do condemnation because remember, condemnation doesn't require no access. It just says the access has to be unreasonable. And at that time, the access got cut off, right? So the court specifically says in that case, yeah, it doesn't matter that he had a license up there because it was only a license. He still retained the implied way of necessity claim. And that's what the court needs to look at. That's all that matters there. We don't, the rest is good context about what happened can be confusing because it was actually the plaintiff pursuing a condemnation, statutory condemnation. But that's the point there is there's a license to use a road, not a legal right, not a right that runs with the land. There's permission from the owner to use it. That's not good enough to eliminate an implied way of necessity. Regarding the NAOS, there's no testimony about valuation of that NAOS or how much is being lost or how much is there even. And so that's all just speculation, right? There was no evidence of this is how much NAOS we're going to lose. For our build project, this is how much we're going to need. NAOS is that percentage of the lot. We heard no testimony about how much property, for example, how much land is needed for these buildings. They're a 6,000 square foot building. If that's all on the ground, does it take 6,000 square feet? Okay, what proportion of the property is that? What proportion is already set back anyway? In the Gong's case, is that whole western portion of the property, that's going to be NAOS or can be dedicated as NAOS. So there was just none of that evidence for the court to feel confident in that any number that's being thrown out there is reasonable. And the fact that we have two round $400,000 figures, I think, is very telling and does not have a proper foundation. there's a lot of discussion on approvals from the city, and the court should note that both surveyors did say it's possible. I haven't met a surveyor who says, yep, I'll guarantee you that path through there, just like I've not met a lawyer who says, I guarantee we're going to win this case. They don't do that. What they do, and what Mr. Sixton in particular does, is works with the city constantly. He has thousands of cases a year. He's getting surveys done. He's getting access. He's designing the engineering for these roads to work to meet the requirements of the city. He testified that that's what he does. The other thing, so that I don't forget that, is Mr. Wickman also testified. He didn't show up and say, yep, I just want this random road here. There was a lot of thought put into it. They didn't just blast a straight line through. Why? Because they tried to go around everything. That was his express direction. And we're not saying he didn't tell him, yeah, hey, look, I'm on 998D. I need to get to Happy Valley Road. Can we make that happen? Yeah, that's what he told Sadberry. Sadberry also did exactly choose where that path went. And if we remember, the court recalls, his words were, yes, this is exactly where I would put the easement. If I did it again today, I would put it right here. Mr. Sixton said the same thing. I think above all of this, it's not the court's job. It's not the court. The court doesn't have to wrestle with, I wonder if and what concessions the city of Scottsdale will require when a driveway permit is put in. As you heard in the testimony of the surveyors, that's built in, particular Mr. Sixton, that's built in. There's a 20-foot easement. Why? Because you don't have a 20-foot road. It's not right here. It's within that easement that you have the road. So you have room for your pull-offs, and you have room for moving around stuff within the easement. And the other thing is, as Mr. Wickman testified, he met with the city of Scottsdale. He met with them before he put the easement or had the easement drawn, and asked what these requirements are. And based on that, he requested the easement to be drawn by an individual who does this regularly within the city of Scottsdale. The bottom line with that, though, is, again, the court doesn't have to wrestle with that, because the law says nothing about whether there's HOA approval or something, or whether there's a pre-approval for a permit for an easement that doesn't exist. Mr. Wickman testified they told him to go get an easement, and that's what he did. That's what he's trying to do. That's how the process works. They will, in fact, I don't know that you can even apply for a driveway permit without showing evidence that you have a right to the land that you're asking for the permit for. I think there was a little bit of misstatement of Mr. Sadberry's testimony. I think I cleared that up. The start and end point, again, yep, that's clear, but nobody told Mr. Sadberry where to run that easement. That was left solely to his professional opinion. He also didn't come up with the southern route himself. He was asked whether it could be feasible there, and he said, you could put a bridge there. And what does that cost? What does it cost to build a bridge? We've talked a little bit about what the city of Scottsdale requires or might not require. We've talked about the difficulties of pouring concrete walls in. I think that the court doesn't have to speculate much to guess that putting a bridge in there would require pretty expansive footings and shoring up against the wash that it was designed, or it was purported to go through. Another couple of quick notes. The Gongs didn't buy relying on anything. Miss Gong testified several times. I bought this as is from the bank. That's not relying on anything. As is as is. I don't have any idea where this $800 per square foot came from. It's not a simple math formula either, because anyway, you cannot measure the diminution in value of land on the basis of a hypothetical house you might build. So if they were going to put a $60 million house and it's 25% of that, can we do that? No, that's just not, that's speculative. The cases I cited say that's the kind of evidence, that's the kind of testimony that's unsupported and cannot be used. The other issue with the testimony on the damages there was, we asked in discovery in Exhibit 41 for all of these documents, for the court will see, for the documents regarding any plans or surveys or anything relating to valuation of this property, and there was none. The court's own trial order and the rules, the Arizona court rules say this kind of testimony should not be allowed or considered. It's significantly prejudicial to plaintiff. We think it would not matter anyway because it is too speculative and is not the opinion of Miss Gong. there was reference to causing or the fact that there was knowledge of a landlock. And I want to just cite to the Seamson v. Davis case, 196 Arizona 411. That case says the landlocked owner's awareness of the difficulty of access at the time of purchase would not defeat the condemnation of a private way of necessity where property had no alternative means of access. So again, I want to make sure also the court recognizes we're not looking for an easement, an implied easement based on use. This is an implied way of necessity, and those are two different doctrines. The use doctrine, obviously, as we might suspect, has some different elements, such as, did you use it? That's not at all at issue here. Regarding the credibility, since that was brought up, I'll just point briefly a couple of times to Ms. Wilson's own client. He said he offered to buy 998F from the Gongs. Both of the Gongs said he never did. I don't know who's right there. I don't care. I guess who's right there. Maybe it happened, maybe it didn't. There's a credibility question there. The valuation creates some serious questions. The opining to this court that the property is worth 1.2 conservatively, and then coming back and saying, oh, this is my dream house, but you put your dream lot up for sale 18 months after you get it. That's not logical. And then you're putting it up 2 years before the lawsuit. So it has nothing to do with the lawsuit. It has to do with listing it for 4 times what you bought it for 18 months later. Mr. Solberg also said when he listed it, he said, oh, that was just a pie in the sky number. Those are his words, pie in the sky. Maybe someone will buy it. But he's sitting here saying, well, 1.2 million. His pie in the sky was 999,000, and then it went down to 779. So when we talk about credibility, I think those are the things that the court has witnessed and goes to the weight of the testimony. There was also no evidence that the road was not feasible or that the driveway was not feasible. We just had the opinions of a few lay people who said, oh boy, it's steep. Mr. Gong did testify, well, yeah, the rocks on his lot looked a lot worse than the driveway there. Nobody testified they were not able to walk it just fine. Nobody testified that after it's graded like any normal driveway, we'll have no problem driving down it. There was no evidence that 998D is in an HOA, and I can tell you from the public records, they're just not. But again, the point there is we don't need approval from a city. The court doesn't need approval from the city. The court does not need approval from an HOA. The court's job is to determine, is there an implied way of necessity here that this parcel is entitled to, and the plaintiff as the owner of this parcel is entitled to. There were no other routes presented. We would have happily considered them in the last, let's see, 6 years since plaintiff began communicating with the defendants. If there's another route, let's talk about it. But nobody put another route out there that would work across the 998 parcels. They just don't want an easement, and I can understand that from their perspective. That's all I have, Your Honor. Thank you.
All right, give me just a moment, please. Okay, we're square on all of the exhibits that have been admitted into the record.
Yes.
Yes.
Okay.
Yes.
All right. I always like to ask at the end of trial. Counsel, thank you all for the high quality of advocacy. It is much appreciated. For the clients, I'm going to take the matter under advisement, and what that means is that I am going to give careful consideration to all of the evidence that has been presented. I will make findings of fact, and then I will apply the law to those factual findings. That is how I will reach my verdict. I will do so in a written opinion, and I will issue that as quickly as I can. It's probably going to be a couple of weeks. I don't want you to be sitting up at night waiting for it. It really will probably take me that long with all of the other responsibilities that I have right now, but I will get it out as quickly as I am able. So we'll show the matter under advisement. And with that, counsel, thank you all.
Thank you.
Thank you, Judge. Thank you, staff. We all appreciate it.
Hey, can you unfreeze the screen for me? I'm just kidding. I'm just kidding.
Do you want these lists
birthday office. Good job.
Those are for you.